And this morning we'll hear arguments starting with case number 17AP0037, entitled In Re KR. Each party will have 15 minutes to present their arguments. Please begin by identifying yourself for the record. And the appellant, of course, may reserve up to 5 minutes for rebuttal. If you're going to do that, let us know right at the start. Both of you probably are aware that these arguments are being recorded. They're posted on the court's YouTube channel. So because of that, please refrain from using the names of children, since this is in Re KR, during your presentation. And I can assure you that all of the judges have read your briefs and we're ready to proceed when you are. So the appellant, Mr. Armstrong.
Thank you, Your Honor. May it please the court, my name is James Armstrong and I represent the mother of this case, Samantha Ratliff. A little cozier here in Wayne County than we usually are when we're in Summit.
We were saying the same thing.
But it is nice to see all of you. This is a pretty straightforward case, and it's based on the recent decision from the Supreme Court in Re RK, which was the primary focus of my appellate issue. In fact, the sole assignment of error in my brief, Your Honor. As I'm sure the court's aware, in Re RK was a situation that came out of Franklin County in which the trial court went forward on a permanent custody hearing trial without the mother's presence, and had granted the attorney for the mother permission to withdraw at the morning of the hearing. Your Honor, that case was affirmed by, I believe, a 2-1 decision by the 10th District. It was taken by appeal by the Supreme Court. I found out about it after I got appointed this case by the Wayne County Juvenile Court, and because it was a pending case involving the almost identical issue, filed the appeal here. Fortunately, the decision came out before this court had to make a ruling, and before I actually filed my reply brief, so I was able to address it in my reply brief. The ruling of the court was when the state seeks to terminate forgive me, I forgot, if I may reserve 5 minutes.
Yes, you may. Thank you.
I'm sorry about that. As the court's aware, a lot of times in Summit County, the prosecutor doesn't waives their rights, so it's nice to see the Wayne County prosecutor here. But as I was stating, the ruling of the court pursuant to the syllabus was when the state seeks to terminate a parent's parental rights, the parent has the right to counsel. The parent cannot be deprived of the right to counsel, that right, unless the court finds that the parent has knowingly waived the right to counsel. Waiver of counsel cannot be inferred from the unexplained failure of the parent to appear at a hearing. Here we have a situation where the mother actually was served by publication. The counsel was granted permission to withdraw at the morning of the hearing.
Didn't the court apply the test in Sadie, saying the court had to inquire and make sure that counsel attempted to communicate with the client, attempts to communicate, attempts to obtain cooperation first, and then the second part of that test is to verify that the failure to communicate resulted in counsel not being able to assert the client's wishes. In other words, there's got to be a discourse between the court and counsel, which wasn't present in RK, whereas in this case there seemed to be significant inquiry about counsel and the contacts he had with the mother.
Your Honor, I would state that this is a unique case where typically we come to the Court of Appeals saying the trial court made a mistake. Here I'm saying the court needs to reverse this back to the trial court because the law as found by the Supreme Court in Re RK, and forgive me if I get KR and RK backwards and forwards here.
I was thinking the same thing.
But in the Supreme Court case, that has changed it when the trial judge went through the litany with the judge. I'm not going to sit here and dispute that that wasn't the existing law at the time. But we're now dealing with the law as dictated by the Supreme Court, and the Supreme Court says that unless the parent knowingly, intelligently, voluntarily waived their right to counsel, you can't grant that motion to withdraw.
So
And
there's no longer an implied waiver by a parent refusing to cooperate and refusing to show up? Say the parent has no interest in the child and just disappears.
Well, I'll answer that question two ways. First of all, I would like to correct the record. In Justice O'Donnell's dissent, he goes through a litany here on the last page. It's almost this last full paragraph, in which he talks about at the trial court in the Franklin County case, counsel indicated, I'm quoting, to the juvenile court that he had prior difficulties communicating with his client. The record further reflects that AS had attended earlier court proceedings involving this matter and knew of the permanent custody hearing date. In addition, counsel for AS sent her a letter informing her of the time and nature of the proceedings, that she needed to attend, that if she failed to appear, the trial court would likely go forward without her, and that he would request to withdraw. Despite receiving that communication, AS failed to appear at the hearing, and there's no evidence in the record that she attempted to contact counsel or that the court to explain why she was unable to attend. That's what the Supreme Court, at least in the dissent, which talked a little bit more about the factual implications, indicated in the Supreme Court case. So I would say that the analogy that my honorable opposing counsel brought out, that this is a different situation, distinguishable, really isn't. Not if you look at what was stated in the dissent, and that's the best way to see what's in the record of In Re Arche. The second issue, Your Honor, is I would agree with the court, and I've been in this situation, but it would be a lot more, I think the court would have been a lot more on solid ground if the permanent custody motion wouldn't have been filed well before the 1 year, that they wouldn't have had a contempt and an active warrant on the parent, knowing that she was going to be picked up. And from what I understand, she actually got picked up right before actually the trial judge issued the ruling on this. And for example, to just change the facts a little bit, if we were at a year and a half into the case, or a year and 9 months, where you only have so much time before statutorily you have to make a determination, I would have been a little bit, I would have had more understanding of the fact that the court just was forced to go forward statutorily. Here, the court was not really forced to go statutorily. The court had the option, because they knew they were eventually going to pick, well, I don't want to say they knew, there was a probability that they were going to pick up this mother on the warrant. She actually got served again by publication, so that the argument that she knew about the hearing is less persuasive in this case than it was in the case that the Supreme Court handled, where the mother clearly knew, and in fact her counsel, according to what Justice O'Donnell wrote in the Senate, was notified. And by letter saying, you have to show up, there have been problems with communication, if you don't show up, the court's going to go forward and I'm going to withdraw. I don't recall anything in the record that's similar to that. Again, in being fair to the trial court, if you look at the existing law at the time, I don't think the trial court made any error based on the existing law at the time. We're here solely because of the change in law that has taken place by the Supreme Court's decision in Re Arche. And as I stated at my opening, that's the basis for the appeal, and that was really the sole basis of the appeal, because I knew this case was pending in the Ohio Supreme Court. Had the Ohio Supreme Court ruled the other way, this court would have had a very easy decision. But because the Supreme Court ruled the way it did in Arche, quite honestly, I think this court also has an easy decision, that it has to remand the case back and provide counsel for the mother and conduct the hearing again. And when you look at the record, there's really good reasons to. You had a psychologist, Dr. Bowden, who testified about an evaluation that was something like 7 or 8 years old, and the fact that she never had a chance to even evaluate the child. And you had a guardian ad litem that actually never even was called to testify to justify her decision regarding, or her recommendation regarding the permanent custody motion. And this was a 10-year-old child who actually had a relationship with the mother, so it's not like we're dealing with an infant as well. So in certain aspects, the facts of this case, based on what we do know about the facts of Arche, are even more persuasive to remand this to make sure that she had counsel. And I simply point out, not so much as assignment of errors with regard to Dr. Bowden and those questions, but that's just an example of what the benefit would have been had mother had a representative there to argue her position and present the case that maybe this isn't the right time for permanent custody. Especially considering that they hadn't even come, I think by the time they actually had the hearing, it may have been at the one-year part, but by the time it was filed, it had not been, this was not a 12 to
Well, of
22
course.
situation.
They can file any time. I mean, there's no time limit as to when CSB can file for permanent custody.
There isn't, Your Honor, but in this case, we do have a due process issue with regard to right to counsel, which is one of the disputes that I have with, again, my honorable opposing counsel with regard to the standard review. Since this is a constitutional issue, the right to counsel, I submit that it has to be de novo. And I wasn't really arguing that the court should have granted the motion to continue. I put that in there as an example of what would have been a better way to decide.
Can there ever be an
process.
implied waiver of counsel in a permanent custody hearing
Based on the
when
recent,
somebody doesn't show up?
based on the recent decision in the Supreme Court case, I think the decision to withdraw as counsel needs to take place before the hearing actually goes forward. And I think that's the only fair way to do it, because that way the court is on notice, or the court has issued that order granting counsel the permission to withdraw, and then the parent is on notice that you won't have counsel, and if you want, and I know other courts do this, I know one really well, that will allow somebody to withdraw and will put in the order that if mother or father wants counsel, they need to reapply for counsel and give that opportunity. I believe that's what they do in Summit County on many occasions.
Got about 4.5 minutes. You want to reserve?
I'll reserve the rest. Thank you.
All right, thank you. All right, Attorney Newton.
Thank you, Your Honor. May it please the court. My name is Joshua Newton. I represent the Appellate Children's Services Board in this matter. As appellate counsel has just described, the primary issue, obviously, in this case is the right to counsel and the withdrawal of counsel in a permanent custody proceeding. And as the court had instructed us to supplemental brief, the new Supreme Court decision in this matter issued in January is pretty on point here. And again, as with appellate counsel, I have been having issues saying in re KR, in re RK, so I'll try to do my best here. I think in the questioning that this court was presenting to the appellate counsel really gets to the primary difference between these two matters. In re RK, what was on the record based on the briefs of the parties in that matter as well as the majority opinion, it would seem that there was no inquiry. Prior case law in most of the districts of Ohio would seem to indicate falling in line with the in re Rachel G, in re Savannah M, out of the 6th district, which this court adopted, I believe, in re TK, that there has to be an inquiry of the trial counsel as to a party's attempts to communicate and cooperate with their trial counsel. That inquiry looks at the efforts trial counsel made to communicate with their client, also the efforts the client would have made to communicate with their trial counsel, and really what the courts are getting at in that is whether the trial counsel has the ability to adequately and appropriately and competently represent their client's interests at the trial.
But counsel, the judge here didn't necessarily inquire if he was able to ascertain the client's wishes. I think all he asked, and I could be wrong, but I think all he asked was if he'd been in communication with her and so forth. And counsel said, not for the last month, but that he didn't think that he could know what her wishes were.
I actually believe the question was raised
Okay.
on transcript page 10. The court had inquired directly of trial counsel Chris Coleridge. The question was, so you're unclear on how mother, your client, would want to proceed on the motion, to which he responded in the affirmative that he was not aware of how to
But
proceed.
counsel had already said he was unclear, basically.
Basically, in
And the
his
judge was
discretion.
just reaffirming that. But he didn't say, why are you unclear? It's my understanding she had been involved in this case, had had visitation with the child until it was suspended and had attended other hearings.
That is correct, that she had attended other hearings. However, as the inquiry on pages 5 through 10, as well as the subsequent inquiry of the caseworker later in the testimony after the motion had been granted, indicates that it had been a number of months since mother had appeared. My recollection, off the top of my head, would be
She had an active warrant for her arrest too, right?
She did after she failed to appear for a show cause hearing, which was in between. She had been served at the March hearing for notice of the show cause hearing.
And the show cause hearing was for the contempt.
Correct, and that would have been between the date of service and the permanent custody hearing. When she
And-
failed to appear for that was when the warrant was issued.
Okay, so if she appeared for the permanent custody hearing, she would have been arrested.
Yes. She
So-
would have been- or held on bond. To
Well, but my point is, that's kind of a reason not to appear. You're choosing between defending losing your liberty and defending against losing your child. That's kind of a hard position to be put in, right?
That is a difficult position to be in. However, the situation would have been, had she appeared, she would have been arrested right there. She was already before the court, and the court would have proceeded with a bond hearing in accordance with contempt procedures, which is actually what happened later on in the case when she was picked up. And I don't believe,
But doesn't that cut against her waiving her right to counsel? Because that's really the issue. Did she waive her right to counsel?
I understand that, Your Honor. As far as her waiving her right to counsel, though, this court and many others have held that we can imply that waiver based on a long-standing lack of communication despite efforts to communicate. And so in this situation, we don't, as with many cases in this sort of implied waiver situation, we don't have a situation where mother has presented herself to the court to go ahead and openly, knowingly, and intelligently waive her right to counsel. That actually happens quite rarely in these type of cases. But it's worth noting that in Ray R.K., the Supreme Court had the opportunity really to rule something that clearly in their favor, and they don't. What they state is a parent's waiver of counsel cannot be inferred from the unexplained failure of the parent to appear at a permanent custody hearing. They could have stopped right there. A parent's waiver of counsel cannot be inferred, period.
Right. They also said the parent cannot be deprived of that right unless the court finds that the parent has knowingly waived the right to counsel. And I understand it goes on to say cannot be inferred from the unexplained failure of the parent to appear at a hearing. But in RK, it specifically had the information before it that the counsel had notified her that he would in fact withdraw if she did not appear. So that's a pretty strong case for implied waiver, wouldn't you think?
It would be had there been that inquiry that we see in other cases, and those are the cases that the court cited directly in paragraph 6 of its entry. What it really turns on is this inquiry as to the efforts. One of the counterbalances here, that it's an awkward position as a prosecutor to be in to make a sort of a defense counsel argument here, but as attorneys, we're also obligated ethically and beyond that, in terms of ineffective assistance claims, that sort of thing. We need to know our client's position on issues in order to appropriately argue them at trial. And that's something that applies to rights of counsel as well as kind of across the board, not just in permanent custody situations. So the way courts have held this, including this court in the past and in Right TK, would be to go ahead and inquire of those efforts. And there are a number of issues mentioned throughout this in Ray R.K. and the Supreme Court decision. They do take direct issue with the fact there is a lack of on-record inquiry here in this matter. It really seems that the trial made a moral request for a motion withdrawn and then just simply was withdrawn. There's no findings in the entry from the trial court decision, and there were no inquiry in the record that could have clarified this. Here, in our case, obviously, we have several pages of transcript where the court had their inquiry, as well as specific findings the trial court made in its judgment entry granting permanent custody. And in that final entry, the court, in our case, did specifically find that trial counsel has not been able to discuss the motion and is unable to determine what mother's wishes are.
How did the court make that determination that the counsel was unable to determine what mother wanted to do?
Based on trial courts, the trial counsel's assertions on that topic, as well as the trial court's answering of the inquiry that happened. Also during that inquiry, the court did inquire a little bit of the caseworker, just to see if the agency was having similar difficulties in communicating with mother over a period of time, just to try to rule out whether there were any issues where maybe trial counsel's efforts were insufficient because trial court
Was there anything in the record that would indicate he was able to or was not able to discuss the permanent custody motion with her?
The timing of, it's not explicitly.
I'm talking about the attorney.
Right. It's not explicitly spelled out in the inquiry, but comparing the statements that trial counsel made during that inquiry with the date of the filing, for example, of the permanent custody motion through the court record, it would appear that his text messages, his phone calls, his letters, it seems like some of the letters came after the motion, but his text communications and the appointment he would have had with her came at or just prior to the motion being filed. So had she shown up for that appointment, that might have been right at the time that this motion had been filed, and she could have met and discussed that motion.
And that was the time she was supposed to turn herself in to be arrested.
That was after she had been served notice of the show cause, but I believe the hearing was still pending at that point in time.
So there was a point in time she was in the county jail. I think the caseworker visited her once.
Correct.
Was that prior to the hearing?
That was prior to the hearing. That is in the testimony in the transcript from the permanent
Did
custody.
the attorney know she was there, be able to go see her? What was the situation behind that? If you
That I do not recall, but my recollection would be that the time she was incarcerated would have been earlier in the case. As the appellate counsel noted, this hearing took place at or about the 1-year mark of the case. Mother, through the testimony, had been in incarceration during a period in the case. That, logically speaking, would have been prior to the warrant being issued. So maybe could have been after her service. I would have to look at the record in more detail, but it must have been prior to the show cause hearing for which the warrant was issued.
So apparently that's not in the record.
That would be what it appears to be without going through each entry and
Okay.
really arguing it out. Given that that's the primary focus here, I think that as far as the briefs are concerned, the continuance issues or any other due process arguments that were raised by the appellant, I think have been really adequately addressed by my brief, so I'd stand on that in that regard. So unless the court has any further inquiry about the motion.
What's your view on the Sadie decision?
I'm sorry, what?
Sadie, S-A-D-I-E, that
I believe that
was cited in RK.
Sadie, along with In re Rachel G. and Savannah M., all out of the 6th District, this has been the case law in the 6th District, the 8th District, the 5th District, our district, the 9th District, for a good period of time now, and that's what the trial court has been held to, and that's what they complied with here by engaging in that inquiry. I believe that the Supreme Court's decision to cite directly to some of those cases in paragraph 6 and really apply that standard in reaching its decision is just a reiteration that our existing case law should stand. I don't see In re RK as really changing our practice or prior rulings.
Well, that paragraph 6 says the key question in this case is whether AS waived her right to counsel when she did not appear at the hearing. And then they go into the standards set forth in Sadie. So do you think they're adopting Sadie there?
I do, Your Honor. I don't believe that they've made it clear that they are going against Sadie or going against Savannah M. in this matter. The real issue that they take hold with in paragraphs 7 and 8 is just the lack of this inquiry. Paragraph 8, they talk about, we do not know the details, in part because the court did not inquire into them. Had the court of juvenile court in Franklin County just made that inquiry, this case could have been entirely different at that point in time. And in our case, the trial court did engage in that inquiry and make her requisite findings thereafter.
Any other questions? Okay, thank you.
Thank you.
4 minutes, 34 seconds, Mr. Armstrong.
Thank you, Your Honor. Again, may it please the court, James Armstrong, on behalf of the mother, Samantha Ratliff. I just would like to respectfully disagree with my opposing counsel. I don't believe the existing law can stand in light of In re RK, because the court has made it pretty clear that in cases of permanent custody, you have to be very, very sure that there's a knowing, intelligent, and involuntary waiver. That's why I submitted on my initial time in front of the court that it would be better if somebody's going to contemplate withdrawal, that the court issue the order before the day of the hearing, because by the time you get to the day of the hearing, it's really too late for the parent to do anything really about it. The other aspect that came up during my opposing counsel's argument, and this is kind of a troubling aspect in a due process sense. We have CSB filed the contempt. The mother was personally served. I can't remember writing. It's like March 20th, 2017. It was April 28th, the day that the caseworker visited the mother in the Medina County Jail. It was May 1st, 2 days later, when Children's Services filed a permanent custody motion, and then it was approximately 7 weeks at the end of June when they had the contempt motion that the mother did not appear for, Your Honor, and then after that, after the contempt motion, is when service was done by publication, thus indicating that mother may not even know about this hearing, and certainly wouldn't have known that her counsel intended to withdraw. Your Honor, in one aspect of my opponent's argument, I do agree. The matter's brief, the court is aware of the Supreme Court decision that is controlling this matter, and in all honesty, unless there's any other questions, you really don't have any more to add.
All right, thank you very much.
Thank you very much, Your Honor.
Thank you, both of you, for your presentation today. The court will take the matter under advisement. Advise you when you will be advised when a decision is issued in the case. Clerk of Courts will mail you a copy. Also, the opinions are posted on the Supreme Court of Ohio's website, so you can check there as well. So thank you again for your arguments.